Hello, fans of the Freedom Center. This is Dave Rowland, the Director of Litigation. He believes in free markets. He believes in constitutional limits on government. And so for years, on his own dime, on his own time, he would go down to the legislature in Jefferson City and share his ideas on public policy with the duly elected representatives, the people responsible for making the laws. And he never gave them anything of value to get their attention. He did not get paid at all to share his ideas on public policy. But at the same time, Missouri law was written in such a way that he could, in fact, be treated as a legislative lobbyist. And that's what the Society of Governmental Consultants asked the Ethics Commission to find. And they did. They found that Ron was, in fact, acting as a lobbyist, and that you are not allowed to do that in Missouri unless you get the government's permission, unless you register with them and then file regular reports. And by the way, if you ever make a mistake in filing those reports, it's a very serious offense that carries with it potential jail time and fines and all sorts of awful things. And they were saying you have to jump through these hoops before you can lawfully share your ideas with legislators. We had to start out in the Missouri administrative process. We went to the Ethics Commission first, tried to argue that they were misunderstanding the law. They disagreed, and they said Ron Calzone has to pay $1,000, and until he does, he's prohibited from going to share his ideas with legislators. We didn't like that, so we went to the Administrative Hearing Commission in Missouri, and they were going to allow a really in-depth discovery process by the government against Ron. And so we tried to get to stop that. And to do that, we had to go to the Circuit Court for Cole County. This is the Missouri court. And we did get the Missouri Circuit Court to prohibit the Administrative Hearing Commission from going forward until they addressed the substantive First Amendment issue that we had raised. But then the Missouri Court of Appeals reversed that. And we asked the Missouri Supreme Court to reconsider the Court of Appeals decision. They did not. So that was the first wave of this case, and all of this was taking place throughout 2015, 2016, roundabout in there. But then we came back and we filed our federal case in the United States District Court for Western Missouri, which has a judge there in Jefferson City. And we lost in the federal district court, but we lost on a literally unprecedented theory. The judge for the district court there said that she believed the government had an interest in identifying who was trying to influence public policy. Now, this is a government interest that no court anywhere in the country had ever found was sufficient to justify intruding into someone's First Amendment freedoms. But that's the theory that this judge relied on to rule against us in the federal district court. So then we appealed to the Eighth Circuit Court of Appeals. And what happens when you go to a court of appeals is they assign, theoretically at random, 3 of the 11 judges on the Eighth Circuit to hear the appeal. We got Judge Colleton, Judge Shepard, and Judge Strauss, who was a recent appointment. At the argument, Judge Colleton and Judge Shepard seemed pretty hostile to our argument, but Judge Strauss seemed to really get that this is a sincere First Amendment problem. People have the right to petition their government, and that the government can't just put these barriers to doing that, especially when failure to comply with the government's requirements presents potentially some pretty significant criminal penalties. So Judge Colleton and Judge Shepard did rule against us in that appeal, but Judge Strauss wrote a beautiful and stinging dissent where he said, "Look, you can't just be so frivolous when you're ruling that the government can intrude into somebody's First Amendment freedoms." And on the strength of Judge Strauss's dissent, we did something a little bit unusual, which is we asked for a rehearing from all 11 judges on the Eighth Circuit. This is something that does happen maybe 4 or 5 times a year. 4 or 5 times a year, the entire circuit will agree to reconsider a case from below. Now, they get hundreds of requests a year to reconsider those cases, so it's less than a 1% chance that they're going to grant such a request. But they granted it in our situation. They recognized, hey, look, this is an issue of exceptional constitutional importance, and it's a national issue. This is the first time that a circuit court has weighed in on this specific question, and so they wanted to take it very seriously. So in April, we had the rehearing on that argument. And at the rehearing, we felt fairly confident that we had 5 of the judges in our favor, but you've got to get that 6th if you're going to win on the rehearing. And we felt like we were going to get the 6th vote, but we weren't sure right where it was coming from. But today, we found out that, thankfully, we did get the 6th vote. And so by a 6-5 decision, the Eighth Circuit has held that, yes, this is actually a pretty significant First Amendment concern. If you're going to interfere with a citizen's freedom to share their ideas about policy with the people who have been elected to enforce policy, you've got to have a pretty good reason for interfering with that. And they pointed out the only reason that the courts have ever definitively said is acceptable is if there's concern about corruption or the appearance of corruption. And in this situation where everyone agrees there's no money involved, I mean, no one was paying Ron Calzone to share his political ideas. He was not giving legislators any gifts or benefits to get them to listen to him. In the absence of any corruption or appearance of corruption, they said the First Amendment has to win out. That free speech has to be allowed to go forward. So that's a big deal. It's a really big deal. There's still the possibility at this point that the government could ask the U.S. Supreme Court to take the case. And the chances of the Supreme Court taking any given case go up significantly when a circuit court has reconsidered an issue en banc as a full panel. But we think that the way this case was decided, it's pretty unlikely that the government is going to ask the Supreme Court for review. If they do, our response is going to be throw us in that briar patch, because the reason that we take our cases in the first place is because we believe they are issues of national importance. They need to be resolved by the Supreme Court. And so if the government says, we want the Supreme Court to hear this, we'll probably say, yeah, we think the Supreme Court should hear this. Let's do it. But I don't think it's likely. We'll see. In the meantime, the case is going to be sent back down to the district court, and it should be wrapping up in the next couple of months. We should finally, after more than 5 years at that point of litigation, we should be able to wrap up a very, very important First Amendment victory. I want to say a few thank yous. Number one, thank you to Ron Calzone. The thing that our nation needs more than anything else right now is individuals who are willing to step up and take on government policies that are unconstitutional. It is the easiest thing in the world just to sit back and let these policies run over you. and not fight back. A lot of people feel like fighting back would be futile. But Ron Calzone is a fighter, and he committed to the outset to seeing this thing through. Even when the Ethics Commission said, you're not allowed to talk to legislators until you give us $1,000, he said, well, yeah, you try and stop me, I'm going to keep doing it. And we need people like that, willing to challenge this authority, because that gives attorneys like me, and like the second group I'm going to thank, the Institute for Free Speech in Washington, D.C., it gives us the chance to go out and fight these battles. Speaking of the Institute for Free Speech, I actually was at a conference. I'm right now in Colorado Springs, Colorado, and Alan Dickerson, the legal director for the Institute for Free Speech, is here with me. And the way I found out about this case, or about the decision today, we were sitting there in the conference, and Alan finally caught my eye, and he just looked at me. He goes, and I was like, oh wait, something's happened. I got to check my email, and I checked my email, and sure enough, got the notice of the win. But it was really wonderful. Normally, Alan's in Washington, D.C. We wouldn't have been able to celebrate together. But we were celebrating an